that there has been an infringement of privacy, I will establish before the court as to why the restriction on freedom of speech and expression is proportionate.
Well, what exactly is the basis for this statute? It's called the First Family Privacy Act, but I understand that the government enacted it on the basis of security concerns as opposed to privacy concerns.
Your Excellencies, I do understand that there was a very important security threat that was facing the first family as well. However, my plea is strictly this, that their right to privacy was also sacrificed. And here I'll make a point regarding the fact that it is in the context of privacy that we've brought the legislation, besides the security concerns that might exist.
Well, assuming that the legislature enacted it on the basis of security concerns, can we uphold the legislation on the basis of privacy concerns?
Your Excellencies, the legislation has not merely been drafted with regard to the security concerns. In fact, their exposure to public scrutiny and the way the posts have dealt with their private life enhances their security concerns, and therefore there's a direct correlation in between sacrificing the security interest and sacrificing the right to privacy which is involved in the matter. It's not a black and white case, but there are shades of gray that concerns us in the instant matter on that point, Your Excellency. If Your Excellencies permit me, I will submit before this court that there has been a decision in von Hanover versus Germany in which the court said two things. Firstly, that even in public places, there is a reasonable expectation of privacy, and even public figures within their private domain are entitled to a right to privacy. So definitely it's not the case anymore that public figures have abrogated their right to privacy. Your Excellencies, it is also the case, as per the decision in KU versus Finland, that minors are entitled to a greater protection of law under the Convention for Rights of Minors, as well as under the decisions of the European Court of Human Rights. Your Excellencies, that being the legitimate aim, and my opponents having conceded to the fact that there has been some sort of infringement, I will tell you how the infringement is proportionate. Your Excellencies, may I draw your attention to paragraph 20 of the fact sheet. It says, the law specifically excludes the location information whose accuracy permits only a determination of the city or a larger geographical region. Your Excellency, therefore, this does not choke or cause a chilling effect. If I were to make a post saying that the First Lady is in London meeting X, that sort of publication would still be valid. What would not be valid is if I said the First Lady is in London and she's meeting someone at Harrods Knightsbridge. Your Excellency, the law has specifically included information about the location whose accuracy permits the determination up to the extent of a city. Therefore, as long as activities are going on, and I want to report them with respect to which city the activities are going on and what the activity is, that is still permissible under the First Family Privacy Act. What is not permissible is the over-intrusiveness of the media glare and glare of the general public into the private affairs. And if I may draw your attention to paragraph 18.
Why should the law be so wide as to prohibit the publication of the fact that the family has gone on holiday at a particular time in a particular place?
Your Excellency, if I were to report that the family is holidaying Mauritius, for instance, it is still allowed under the First Family Privacy Act because the geographical location is a city or anything larger than the city. What is not permitted is if I said that the family is right now in the beach in Mauritius and there are friends that have joined the family. Your Excellency, therefore, it does not choke or chill the effect of speech. What it does is impose only a reasonable restriction. And surely, Your Excellencies will believe that there is no general interest in knowing whether Talia has fish but no dessert in her dinner.
But you have a provision about picture taking, no?
Yes, Your Excellencies.
And what if a picture reveals where they are? What's your...
Your Excellencies, we have banned the publication of pictures under the First Family Privacy Act
Full stop.
For the principal reason that pictures have a greater effect on the minds of the people and they make the information more verifiable. So if...
Can I argue that point on its own for a little bit? Because on one side you're arguing earlier on the application of reasonable expectation of privacy, but and you used Miller as the authority, but can't we argue by that same virtue that the first family Privacy Act, or Protection Act, as I would like to call it, that it's actually that the first family, they don't, from the date that he stood for elections to become prime minister, they gave their consent or waiver to that right to privacy. They became public figures, and automatically a lot of what they do is public interest, specifically in what you referred to earlier as a time of ethnic tension or political unrest.
If Your Excellencies may permit me, I have exceeded my time.
You answer the question, and then I'll give you 30 seconds, and I mean 30 seconds, just to close your presentation.
I'll answer the question Your Excellency has posted. Your Excellency, in the case of Miller, it concerned a case where there was a voluntary disclosure to a third party.
But isn't the husband standing for elections a voluntary disclosure?
Your Excellencies, in the case of von Hanover versus Germany, in which Princess Caroline's family was photographed as skiing, it was held that it is not in the legitimate interest of the society that people of Monaco have to know.
And it was public curiosity as opposed to public interest. Yes,
Your Excellency. And there was a test of newsworthiness that was laid down and said that inside the pub, if they've been photographed in a public place, it doesn't necessarily mean that it is not within their private domain.
But doesn't the fact that it's a political unrest period give it a virtue of that there is public interest in that case and newsworthiness? And
yes.
Hanover too is a good example, I guess.
Your Excellencies, in fact, that's a...
Just adding to my learned colleague's question, you're in fact aware that both in both judgments of Van Hanover, the court pointed out also that the assessment is made on a case-to-case basis.
Yes, Your Excellency.
And it seems that your law is imposing an overall prohibition.
Yes, Your Excellency. If I may be allowed to answer both the questions with prior permission of this chamber. Your Excellencies, first of all, I do understand that in light of the ethnic tension, there needs to be some matters reported about the first family. Your Excellencies, that is anyways permitted because the reporting of matters is not being barred by the First Family Privacy Act.
Pictures would...
Your Excellencies...
If I have a picture of Carla having dinner with her boyfriend on the same day as this political unrest, it's important to me. And I think we've had a lot of recent cases that are authorities that serve as authorities for that.
Your Excellencies, if I may just use the example of von Hanover II. Your Excellencies, in that particular case, the article concerned the health of Princess Rainer, who's a very important public figure in Monaco. If it's a matter as important as that, then definitely it would warrant a discussion because it's in general public interest. However, in the instant matter, it has also taken into account silly things like where she's been having dinner and what she's been having for dinner. Your Excellencies, I do understand that there is a very important interest in dissemination of information. All I am saying is the dissemination of information is allowed. I can say that the First Lady met so-and-so in the City of London. What I cannot say is that the First Lady, while meeting so-and-so, had this and this and published a photograph. And with regard to the photograph, the reason why we have an objection to it is because the effects of an audio-visual news is in fact much more than how it appears in print. And therefore, if I said that Talia and Carla are right now, say at the London Eye, it would in fact expose them to a greater threat of invasion of privacy and security in light of these ethnic times.
Yeah, I think I was stop there answering the questions. You can have 15 seconds now just to tell us what you really want us to be left with.
Your Excellencies, I will only summarize before this court by saying that in light of the fact that there is a very important national security threat, the state in good faith must be allowed to impose the restrictions which are anyways reasonable and non-arbitrary. And with regard to the First Family Privacy Act, I will only submit before this court that the Act only imposes a reasonable restriction without chilling speech. On that count, I would like to rest my case. It's been a pleasure arguing before this honorable bench.
Now, who is speaking for the applicant in rebuttal?
Mr. President and Your Excellencies, We have one point to make in rebuttal. And the point concerns what this court must do in weighing up proportionality. And it should not take the respondent's argument that the exercise of power has, to this point, according to paragraph 15 and 16, been done reasonably and in a manner which is compatible with the Universal Declarations. What this court must look to is the operation of the Internet Responsibility Act in practice, and the fact that the legislation here makes quite clear that there is discretionary power, that there is no evidence or criteria provided in this legislation to guide the exercise of this power. And it is without such safeguards that the applicant would seek that this court find that the actual operation of the Internet Responsibility Act is not proportionate, even with and acknowledging some degree of margin of appreciation. May it please the court.
Your Excellencies, the only point of sur-rebuttal is with regard to how the Act operates in practice, and I have reserved 3 minutes for the sur-rebuttal. Your Excellencies, I do understand that a discretionary power has been granted to the state. Discretionary power to do what? To collect information. This is not a penal statute which imposes criminal sanctions on the users. Discretionary power to collect information when? Only to collect information on a case-to-case basis. The government is not a repository of all information, and the government is definitely not doing a state surveillance here. All we are seeking to do under the Internet Responsibility Act is that even in these dangerous times that surround the country, we're leaving out the content of information. That's why it's least restrictive. It is proportionate because all we are seeking to do is identify certain users.
Counsel, doing that identification, given everything you've just said, that will make it more difficult for open media to expose abuses by the state forces, I think. Now, tell me if you would agree with that, and then how are we to decide, granted that the Internet Responsibility Act will help the forces of the state to fight terrorism, how are we to pick between these two?
Your Excellencies, first of all, I submit that the Internet Responsibility Act will not make sure that people don't complain about military abuses. Now, should it so happen that there is a post on Open Media and we find an information about a particular user and we track the person down, well, we have to prosecute them under the ordinary laws of the land. And if it so happens that the person has not committed any crime, or if it so happens that we illegally detain such a person, that detention will fail according to the ordinary penal laws. With regard to how the Internet Responsibility Act solves the military problem, Your Excellencies, I'll just give you one of the numerous instances. Now, the Military Secrets Law after the amendment provides that you cannot disclose information about the location of the military. Suppose there's a violation of this law on the website. All we need to do is find out from the website who the person is, what the person's address is, and where historically has the person posted from. And we can immediately go there and arrest that person, prosecute them under the ordinary laws of the land, and make sure all protections, including the right to liberty, right to a free and fair trial under all. So the only thing that the Internet Responsibility Act is in fact aid all our anti-terrorist legislations and ordinary laws of the land in finding out in quick time. You would have to at this moment realize that we are having military activities and there's no scope that the state can strain its resources any further. And therefore, we have to find the quickest of ways in order to have access to criminals and those who break the law and those who are terrorists. And that's what the IRA seems to do, and that's the reason why the IRA should be regarded as a valid legislation by this court today. If that satisfies Your Excellency's question.
Thank you.
The Council on behalf of the state would like to rest its case. It's again been a pleasure arguing before this court.
kept you waiting for a little while, and the reason is that you've set us a difficult task. I'd like to congratulate everybody for the difficulty of the task that you have set us. What we are now going to do is we're going to make some observations on the teams and the speakers that we've heard. We're going to announce then the best oralist for the final, and then we're going to announce the winning team. We're going to start with some comments. Would you like to start?
So I was the quietest, I guess, when we were asking the questions, because I was writing a lot of notes here, and I thought I'd share them with you. And some of them are going to be positive, and some of them are going to be negative, but hopefully constructive for future moots and future borrowing. Applicant 1, Mr. Chen, I actually really enjoyed your presentation skills. You spoke very slowly and clearly. You had great eye contact. You made sure at every point you looked at one of us, so that was a really good skill of yours. The move back to your argument was very good as well. So once we throw you off with a question, the way you swiftly and smoothly go back to your argument was very good, so you didn't look like you were thrown off. One hopefully constructive criticism I'll give you is that you did not refer us enough times to the memorial, to the written document, and by referring us to it could help you do two things. One, making sure that we're on the same point that you were on, and two, you could buy time when you want to think about your next point. A couple of times you were lost in a way and didn't know where to start again from. By referring us to a document, you're keeping us busy and finding a good place for you. But I personally really enjoyed your presentation. Mr. Morrison, you had good reference, because when you started, you actually referred us back to the question that your colleague didn't answer. That was a very good way of starting your argument, and a very good memory for those judges that didn't forget that their question wasn't answered, so that was extraordinary. You did very well in taking us in responding to the questions. We didn't throw you off by our questions, but unfortunately you were thrown off by time more than you were thrown off by